My colleagues and I appreciate the opportunity of discussing with you a poorly understood yet existential issue for the constitutional rights of physicians and surgeons. That's namely the inadvertent violation of the Constitution by the National Practitioner Data Bank reporting provisions of the Healthcare Quality Improvement Act of 1986. The Black Lives Matter, the Me Too movement, and the Human Rights Campaign for the LGBTQ community are a few examples of where American democracy and values have triumphed in bringing dignity and restoring the civil and constitutional rights to those who have been marginalized in the past. Although much work needs to be done, undoubtedly, the enlightenment brought about by these movements will continue to strengthen American democracy. Yet it's shocking that during the same 2 decades, one group of citizens, America's physicians and surgeons, have been increasingly deprived of their civil and constitutional rights by the federal government. To quote Paul Harvey, here is the rest of the story. In the 1980s, an increasing number of lawsuits were brought against peer review groups by physicians whose privileges had been restricted by hospitals. The American Medical Association argued that the lawsuits against peer review groups had a chilling effect on the existential and vital peer review process. In 1986, in response to these concerns, the U.S. Congress passed the Healthcare Quality Improvement Act of 1986. This was signed and became fully operational on September 1, 1990. HCQIA was designed to protect the health and safety of the public by 1, enhancing the peer review process through protection for peer review members from lawsuits, and 2, providing a national repository for reported information regarding medical malpractice payments, adverse actions involving physicians, and this was all purely for monitoring purposes. We will get to that later in our discussion. HCQIA is comprised of 2 parts. Part A is immunity for professional review activity, and it provides peer review members and those who provide information to the peer review committee with qualified immunity from private suits under both state and federal laws. In order to qualify for this stipulation, the process needs to be met with the following. 1, peer review action must have been undertaken in the reasonable belief that the action would further the quality of healthcare. 2, peer review action must have been undertaken after reasonable efforts to obtain the facts. 3, peer review action is in compliance with adequate due process requirements for notice and impartial fair hearing. And 4, peer review action must have been undertaken with a reasonable belief that the facts warranted the action. It is important to emphasize that the intent of HCQIA was to encourage self-policing by the medical profession by protecting physicians who participated as members of the peer review committee or witnesses in such proceedings from retaliatory lawsuits. As a result, the immunity protection, which is provided by HCQIA, is broad and only requires adherence to fundamental fairness. Let us underline that. It requires fundamental fairness for the process to satisfy the act. Part B of HCQIA is the reporting to the National Practitioner Data Bank. It stipulated that starting on September 1st, 1990, adverse actions taken against physicians were to report it to the National Practitioner Data Bank. Since its inception, HCQIA has been the subject of controversy. Many have voiced concerns about the anti-competitive behavior by hospitals and physicians who can potentially engage in what is termed sham peer review under the protection of HCQIA. It's important to understand that a just, equitable, and credible peer review process is the cornerstone of a high-quality and safe healthcare system. The importance of an unbiased and protected peer review system is codified in HCQIA. However, the peer review process may go wrong when in the new landscape of healthcare, which is dominated by large hospital organizations and the big business of medicine, the peer review system may be misused for reasons other than to ensure compliance to the highest standards of professionalism in the interest of the public and the profession. In those instances, due to the immunity protection, which is afforded by HCQIA, contrived allegations of incompetence or disruptive behavior may be used to retaliate against physicians. Clearly, such a potentially unbecoming application of the peer review system was never foreseen under HCQIA. Nonetheless, medicine has undergone significant change since 1986, and in 2023, the perception of sham peer review is an unfortunate reality. Even if sham peer review is just a perception, it presents a grave danger to the existential institution which has defined medicine for many decades. On the other hand, if sham review is real, not only does it threaten the very foundation of medicine, but it threatens the well-being of the public, and this is the group that HCQIA was designed to protect. The exact frequency of sham peer review is uncertain. But according to the National Practitioner Database, hospital disciplinary actions, including perceived sham peer review, average 2.5 per year per hospital. This number does not include the rate of false allegations made against physicians in order to coerce settlements without a report, which occurs at a rate that is at least 4 times higher. This correlates with a 5-figure number that is common enough to have a real impact on the growing epidemic of resignations, burnout, and poor morale among physicians and surgeons. It is important to understand that unlike 1986 and 2023, in most hospital organizations, peer review committee members are not always independent. Members are typically hospital-employed physicians that have signed an agreement to make decisions, including those about peer review, that comport with expectations, metrics, targets that are set by administration of the system. At times, this requires physician members to accept the political or strategic goals of the hospital system that may want to exploit sham peer review for the administration's business purposes. A hospital organization that selects this route becomes immune under HCQIA from any lawsuits by a terminated physician merely by labeling these actions peer review. Most hospital bylaws grant the hospital the right to remove the medical executive committee members that are unwilling to comply with such capricious decisions. While the original intent of immunity was to protect the judgment of physicians about the medical competency of their peers, it has now been co-opted to protect political decisions such as terminating difficult physicians who are bad for business. In addition, most hospital-appointed peer review committee members lack specific training and are not experts in a specific field. However, the judgments of hospital-appointed members are at a significant risk of being biased by personal and professional ties and administrative expectations. These unfair issues add up to investigations that are often incomplete and have tremendous adverse consequences to the practitioner. The remedy for an accused physician facing grave professional consequences is to file a lawsuit against the perceived sham peer review. But the hospital has a very potent ace in the hole. The legally guaranteed immunity allows hospitals to keep their actions confidential and information privileged from legal discovery. It also allows hospital administrators to officially distance themselves from the accused physician for several reasons and from a process they know as corrupt or fear of being blamed for a negative outcome from the proceedings. A physician is most likely to succeed in court when there is evidence that the procedure that was used in the investigation and decision-making process was fundamentally flawed. Although courts may be important game changers for the problem of sham peer review, primarily for financial reasons, most affected physicians do not take legal actions. Suing a hospital is expensive, time-consuming, and requires enormous mental resolve. In addition, most physicians and surgeons are not familiar with these complex issues and only find out about them when they become subject of supposed sham peer review. The second area of controversy, which is even more important than the first, is the consequences of reporting the adverse actions by the National Practitioner Data Bank. It is important to understand that the National Practitioner Data Bank is an agency of the federal government under the jurisdiction of the Department of Health and Human Services. Peer review actions are reported to NPDB. In turn, NPDB only publishes the reports, but does not investigate the adverse reporting by the reporting entities. Let me reiterate. The federal government does not investigate the adverse reports and allows the reporting entities to go unchecked. HCQIA became law as the medical system was undergoing significant organizational change. In the years which preceded the congressional hearings in '86, most physicians were private practitioners who practiced in hospitals by virtue of holding privileges at that hospital. In the 1980s, there was effectively an organizational and an administrative wall between the medical staff office governance and the hospital administration. Fast forward to the drastic changes in healthcare since 1986. In 2023, healthcare has been consolidated into increasingly larger hospital organizations. Payment for healthcare services has become consolidated under more powerful governmental and private insurance carriers, and the majority of physicians are now employed. The framers of HCQIA did not foresee that in 2023, hospitals and employers will invariably deny employment or hospital privileges based on the NPDB report, which would outline loss of privileges in a hospital or relinquishment of privileges under investigation. Such an adverse report results in the inability of the physician to obtain employment or practice in a hospital. I will repeat, a National Practitioner Data Bank report for loss of privileges or relinquishment of privileges under investigation essentially ends a physician or surgeon's career. Therefore, in 2023, the unintended consequence of reporting the adverse peer review actions, which is an agency of the federal government, can provide the constitutional and civil rights of said physicians with violations. The NPDB reporting provision of HCQIA, once again, violates the constitutional and civil rights of said physicians by violating the 5th, the 8th, the 9th, and the 10th Amendments of the Constitution. Let us look at these more closely. The reporting by the federal government of an action which has not been investigated by the federal government violates the 5th Amendment, which is the right to due process. Under HCQIA and state laws, the peer review proceedings are confidential and privileged. In the constant context of all this secrecy, the peer review process often lacks reasonable and fair procedures. Lack of any discovery for the physician, limited access to medical records, inability to compel witnesses to attend the hearing, burden of proof against the accused, conflicts of interest often ignored. Private hospitals have successfully argued that they are not bound by the same due process rules as state actors, but they are bound by the U.S. Constitution. However, once it is determined that punishment will be imposed on the physician, it is the agency of the federal government, the Department of Health and Human Services, that reports this to NPDB, and causes most of the damage to the physician's career. If the Health and Human Services Department ignores credible claims of due process violations by the accused physician without performing their own independent investigation, their report is therefore in violation of the Fifth Amendment. The degree of due process required is flexible according to the demands of the circumstance. In one extreme, someone accused of murder facing the death penalty, and on the other extreme is a physician whose career ends as a result of a report. The hospital has the right to avoid a protracted legal battle every time they act to protect patients against incompetent physicians. The determination turns on how much risk of an enormously erroneous deprivation of physician liberty was caused by the proceedings that were used, and the probable cause, if any, of additional and substitute procedural safeguards. A final common problem with due process is that the written decision by the hospital hearing panel does not articulate clear standards of competence that are capable of objective application. Without such standards, such a decision might be deemed invalid due to the legal doctrine of void for vagueness. Similarly, the concept of formal investigation is unduly vague. The performance of physicians who are investigated, which often lead one to have to guess whether the investigation is considered to be formal before the physician resigns his privileges. The lack of clarity of the due process ends up basically violating the Fifth Amendment of the Constitution and takes this right away from a physician and surgeon. In addition, the Eighth Amendment is violated. In 2022, over 1,000 U.S. physicians had a report filed by NPDB indicating their hospital privileges were revoked. This action officially blacklists a physician as untouchable by other hospitals, medical boards, insurance carriers, other entities which are important to the career of a physician. Without the ability to obtain privileges at other hospitals, a physician's career is terminated. This disparate treatment of physicians versus hospitals highlights the cruel and unusual nature of physician punishment, which is imposed by the reporting of the federal government of an action which has not been investigated by the federal government. It is basically hearsay. The reporting also violates the Ninth Amendment of the Constitution. This is the rights that are granted by the state laws cannot be preempted by federal laws under the Supremacy Clause. The physician is licensed to practice medicine under a state law known as the Medical Practice Act. The effect of adverse reporting by the federal government is to prevent the physician from exercising his rights, which are authorized by state medical licenses. When a hospital revokes the privileges of a physician due to a clinical reason, state statutes require the medical licensing board to perform their own independent investigation of the evidence against the accused physician. Only a small minority of adverse reports that are made lead to any disciplinary action by the state licensing board. Licensing boards are state actors and are therefore obligated by the 14th Amendment to guarantee the constitutional right to due process of the accused. Despite immunity, the Medical Practice Act of state laws allows for oversight of board decisions by courts. Most hospitals are not state actors, provide due process with far less rigor, and vigorously fight against judicial oversight of their decisions. In addition, when physicians that are judged as being incompetent by the hospital but exonerated by the state board are reported by the agency of the federal government through NPDB, it supersedes state authority in violation of the Ninth Amendment. Finally, this reporting provision also violates the 10th Amendment. The 10th Amendment says the powers not delegated to the federal government by the Constitution nor prohibited by it to the states are reserved to the states respectively. As in the case of the 9th Amendment, the physician is licensed to practice medicine under state law. Adverse reporting by NPDB, an agency of the federal government, without due process through the federal government, prevents the physician from exercising his rights under the state license and represents violation of the 10th Amendment. So in conclusion, there's a dire need for legal action to reform HCQIA and the reporting portions of HCQIA under the National Practitioner Data Bank. In addition, there is need for a corresponding insurance product to reclaim the constitutional rights for all physicians through legal action. After all, protecting the physician community ultimately translates to better care for the public. It is time to acknowledge that physicians' lives matter too. Thank you for the privilege of sharing this information with you. We are also sharing some selected references which may help further discuss some of the points which were brought up in our presentation today. Thank you.